Good afternoon, everyone. I begin by acknowledging the traditional owners of the lands on which we meet. I pay my respect to their elders, past, present, and emerging. Thank you to Carers Western Australia for the opportunity to speak at today's wonderful event. It's a real privilege to be able to join you at the Optus Stadium from Melbourne, thanks to the miracle of technology. I really love the theme of this year's conference about carers navigating identity, change and belonging. It's such a relevant topic in the area of law that I practice in. I represent parents of intellectually disabled and autistic children in NDIS access and funding matters. And I find that the unpaid carer often has multiple identities and roles. You know, they're the support worker, the support coordinator, the therapist, the driver, the plan manager and the advocate. As well, they're the parent, sibling, partner, relative or friend of the person with disability. There's a lot of change in the NDIS. There's constant reform of the legislation and the policy frameworks. The agency is often changing and updating its operational policies and IT systems. And there's quite a high turnover of staff in the agency and its contracted local area coordinators and early childhood partners. And I think that ultimately what the unpaid carer wants for themselves and the person they're caring for is belonging, and they want to participate fully and fairly and freely in society, and they're looking to the NDIS and other systems for the supports to do just that. In my talk, I want to focus on the NDIS legal framework. So I'll start by explaining what that framework is. It consists of two things. So first, the NDIS Act passed by National Parliament in 2013, just before the launch. The Act provides the high-level framework for the scheme. The second part of the legal framework are the various sets of rules, and the rules set out the operational detail of the scheme. So there are specific rules about access and eligibility for NDIS. There's rules about funded supports, nominee arrangements and plan management and other parts of the NDIS. I do note that there were some changes made to the NDIS Act, and there were new rules that came into force on the 3rd of October. And we don't have time to go into those in detail, but the effect of them is to restore the original intent of the scheme. In my view, they don't change the fundamentals of the current framework. So in talking about the NDIS legal framework, I want to even narrow that further to talk about the 4 key areas of where that framework intersects with the interests of the unpaid carer. Those 4 areas are objects and principles of the Act, the reasonable and necessary support test, plan management options, and nominee arrangements. Firstly, let's talk about the objects and principles of the NDIS Act. So the objects of the Act are set out in Section 3, and they consist of about 10 or so sort of aspirational statements about people with disability. So, for example, I won't go through all of them, but some of the objects include to support the independence and social and economic participation of people with disability, to support their choice and control, to provide national consistency in receipt of supports, and to promote service quality and innovation. Now, none of the 10 objects actually refers to carers. They're all focused on the person or people with disability. However, Section 3 does say that in giving effect to the principle, the objects, that regard must be had to the broader context of disability reform, including the Carer Recognition Act of 2010. And the Carer Recognition Act contains something called the Statement for Australia's Carers. And that statement contains 10 principles for carers. And again, like the objects in the Act, the 10 principles for carers are sort of broad aspirational statements. So, for example, the statement says that carers should have the same rights, choices and opportunities as other Australians. It also says that the valuable social and economic contribution of carers should be recognised. And it says that carers should be supported to enjoy optimum health and social well-being. So moving now to the principles of the NDIS Act, they're in Section 4. They actually do, in 3 places, talk about carers and are principles about carers. So the first is that there should be certainty for families and carers that the person they're caring for receives disability supports for their lifetime. A second principle expressly states that the role of families and carers should be acknowledged and respected. And a third principle says that the relationship between people with disability and their families and carers is to be recognised and respected. So those principles are guiding principles for actions and decisions under the NDIS Act. You say, you might ask me, well, why are these objects and principles so important? They seem to be, very aspirational and broad. Well, the answer lies in what's called the purposive approach to statutory interpretation. And this is the principle that in interpreting a provision of an act, the interpretation that would best achieve the purpose or objects of, as stated in the Act, is to be preferred to each other possible interpretation. So, in other words, the purpose and objects provisions, and that includes the principles provisions of the NDIS Act, actually guide the interpretation of all the other sections in the NDIS Act and the regulations that sit under the Act. And this argument may be used in advocacy in NDIS planning and access and other matters, like and be put in submissions, in written submissions and oral submissions. So moving now to the reasonable and necessary support test in the legislation. So a participant is only funded for reasonable and necessary supports in the NDIS plan. And one of the key criteria for working out what's reasonable and necessary is considering what is reasonable to expect families, carers, informal networks and the community to provide to the participant with disability. So, for example, it's reasonable to expect that the parent of a 4-year-old child, whether or not they have a disability or developmental delay, to provide a high level of care and supervision to the child. And because it's reasonable to expect that basically the NDIS won't fund that type of support as a reasonable and necessary support. Turning to respite, which I know is very important for carers. An NDIS plan does not directly fund carers for respite. However, the plan may fund as a reasonable and necessary support for the participant with disability supports that might have the effect of providing respite to the carer or otherwise help to sustain them in their caring role. So, for example, the plan might fund as a reasonable and necessary support some short-term accommodation for the participant. And when they go on that short stay, that has the effect of giving the carer a break. Or the plan might fund some support workers for a support worker to come and assist the participant at home, and that would have the effect of relieving the carer of some of their caring burden of that person. Reasonable and necessary supports may also include training and education for carers to build their capacity to support the participant. Sometimes the question comes up from clients and others that, does the NDIS fund family members to provide care supports to a participant instead of paying an external support worker? The answer is no in general, but there is an exception, and that's if there are exceptional circumstances. The examples of the exceptional circumstances given in the NDIS operational guidelines include if there's a risk of harm or neglect to a participant, or if there are religious or cultural reasons, or if the participant has strong personal views about their privacy or dignity, which means that only a family member can provide them with the support they need, and so the NDIS should fund it under this exception. Deciding whether there are exceptional circumstances, the agency will look at the circumstances of each case, the participants' express wishes, what's reasonable to expect family members and carers to provide without payment, and importantly, whether other options to find a suitable external provider of supports have been exhausted. So moving to the third area of NDIS plan management. The legislation provides for 3 options for plan management. So the first is agency managed. So in this option, the agency receives the provider invoices from the participant and processes and pays them. The participant must use registered providers for their supports. The second option for plan management is for the participant to engage a registered plan manager to manage their plan and their funding. And the plan manager receives and processes the provider invoices, manages the budget, ensures the participant doesn't go over budget, etc. If a participant uses a plan manager, they can engage both registered and unregistered providers, so there's a bit more flexibility in that respect. The third plan management option is for the participant to self-manage their plan, and if they have a nominee, that the nominee can help them self-manage the plan. And in this scenario, the participant or the nominee receives and processes the invoice. They might, through the NDIS portal, they might have their own accounting software to help them, or an Excel spreadsheet. And if a participant is self-managed, they can use both registered and unregistered providers for their supports. Now, options 1 and 2, so agency managed and plan managed, are generally less administrative work for participants, and by extension then often their carers, than the third option, which is self-management. But the choice of plan management is a really personal one. It's what's best for a particular participant and their family. Just it really depends on their preferences and their personal situation and the time they have to manage a plan. There's no right or wrong way of doing it. Moving on to the fourth and last area of nominee arrangements. A nominee is a third person who is appointed by the agency to act and make decisions for an adult participant in the NDIS because the participant doesn't have the capacity to act or make decisions for themselves. So, for example, they might have an intellectual disability, which means they don't have capacity. In many cases, the appointed nominee is the person's primary carer. If the participant has a legal guardian appointed by the WA State Administrative Tribunal or an equivalent body, and the guardianship powers include the services power, then the agency will generally appoint the legal guardian as the nominee. The Act sets out two types of nominee. The first is correspondence nominee. So a correspondence nominee can receive and respond to notices and letters from the agency to the participant. The second type is a plan nominee. And a plan nominee can act and make decisions for the participant about their plan. So, for example, the plan nominee can attend plan reassessment meetings. They can check the plan, make change of circumstance requests, make internal review and external review applications, and sign service agreements. Usually the agency appoints the same person to be both a participant's correspondence and plan nominee. If you are a nominee for a participant, it's really important to be aware that you do have some legal duties under the Act. You have legal duties to the participant and legal duties to the agency. The legal duties to the participant include to act in their best interest, to consult with them about their NDIS matters, to try and develop their capacity to make their own decisions in the longer term, and to avoid and manage any conflicts of interest involved in your nominee role. The types of legal duties a nominee has to the agency is to provide information to the agency when asked and to respond to the agency's other requests. There's also a duty to advise the agency of any changes in your circumstances that might affect your ability to act as a participant nominee. So if you become sick or unable to physically do the role, you should tell the agency about that. And just quickly, I wanted to make note that the nominee arrangements I've just described don't apply to child participants, so participants under 18 years old. In most cases, a child participant's parents or legal guardian will automatically be their child representative. And as such, they can act and make decisions about the NDIS on behalf of the child. There are some instances where the agency may need to appoint someone other than the parent or guardian as the child representative. For example, there might be a grandparent or an aunt or uncle who is caring for the child. There are special provisions, that govern that. So to sum up, an unpaid carer is recognised and impacted in various ways in the NDIS legal framework. I know that the framework, in addition just to the everyday bureaucratic grind of the NDIS, can be really challenging and tiring for carers to navigate. The current reforms flowing from last year's independent review of the NDIS arguably may make it more challenging in the future, but let's see. But I'd encourage carers to get help if they feel swamped from carer support groups, from disability advocates, from support coordinators, local area coordinators, legal services, including legal aid, community legal centres and private lawyers. And get educated, just like what you're doing now. Attend great conferences like this and stay up to date. And on that note, I want to thank you for listening, and I hope that this session was valuable. It is a pre-recorded session, so I really look forward to catching up with you in the live question and answer. Again, thank you very much.
Excellent. Thank you, Angela. That was very informative. We do have a question here on Slido, and keep submitting them, or we'll throw to the floor in a second as well. The question is, if Section 4 of the NDIS refers to the care of carers through reasonable and necessary supports, then why are they removing items like house cleaning and garden maintenance that help us function in daily living?
It's a good question. Some of those things, I mean, the principles guide the interpretation of the reasonable and necessary test. And one of the criteria of the test is that the NDIS the NDIS will only fund the disability-related support. So some of the things they're removing are arguably everyday type of supports. So there are legal reasons, but I think, as we all know, there are also the NDIA is finding creative ways to cut funding because of the cost pressures on the NDIS. And one of the other principles in Section 4 is the financial sustainability of the scheme. So sometimes the NDIA, will refer to that principle to guide interpretation. So it's a very complex sort of balance of principles. But it is a really good question. And, to be honest, I see the NDIA don't following legal tests really that well. It can be quite controversial, and yeah.
Excellent, thank you. Were there any on the floor questions that people wanted to ask? Okay, over here.
Yeah, I just wanted to ask about, at the beginning of this talk that you gave us, you talked about care and support for the lifetime of the person with a disability.
Yeah.
What I find very frustrating about that and the statement is that when you have a plan review every 12 months, you have to fight to keep that support for a lifetime. My daughter is in her own unit, was an SDA housing. It was agreed on when she went and submitted her application for it that, yes, she needed one-to-one support. I've now got it hanging over my head that NDIS are going to remove that. She's going to be forced to go into at least 1 to 3, which is totally unsuitable, and that's why she was granted 1-to-1 in the first place. So this thought of a lifetime of knowing that my daughter's going to have care and support, sorry, it doesn't exist. I worry continuously as to what's going to happen, and every 12 months I have to fight and fight and fight. I am getting older. I am not going to be here to fight for she's much younger than me, obviously. Who's going to fight for her? Why does it have to be every time you go to review, they change the rules, they change someone just decides that they don't read reports or anything like that, and you've got to fight again. There's no guarantee that my daughter's going to be supported for the rest of her life. And who's going to fight for it? That's my question. This care and support for a lifetime's a joke, because to me it's not there. It's just not there. Thanks.
Yeah, I know a lot of people in the same boat, and I too have a brother in the NDIS, and I'm his nominee, so I feel that panic too at every plan review. So I really understand where you're coming from. Your daughter, as a participant, will always be a participant, but I totally understand what you're saying, that every plan review, the rules seem to change, there are cuts. And, you know, that's why I wanted to educate people about those principles, because that when you go to your plan meeting or plan review, you can argue that this is a principle that the NDIS planners are overlooking. And, you know, like I said in answer to the other question, yes, another principle is ensuring the financial sustainability of the scheme. So, but, you know, I would still urge you to advocate that, you know, this was the intent of the NDIS, and that's why it is in the high-level principles of the Act that parents and families and carers should have certainty. So, you know, I understand where you're coming from. I don't know what the answer is, because, you know, like the changes are somewhat out of our control, but you know, I just encourage you to raise that principle in your advocacy in the plan meetings, that you know, NDIA changing the rules every plan meeting is not giving me certainty, which is denying the very, you know, one of the fundamental principles of the scheme.
Excellent, thank you. Thank you for the questions, and thank you very much, Angela. It was great listening to you talk.
Thank you for having me.